Hi everyone, I've just been told that we're live online, so thank you for those who've come in, braved the horrible weather, and for those of you in the comfort of your own homes, ideally watching this online. Today we're going to talk about conciliating ethically in the Land and Environment Court. And the way we're going to do it is, firstly, we're going to talk about the statutory basis for a lot of your ethical obligations as solicitors and barristers. And then run through some scenarios that we've either come up across, against, or brainstormed that could come up. So often we're going to be focused almost entirely on Section 34 of the Land and Environment Court Act. For those of you who aren't familiar with it, the Land and Environment Court has a power to basically force people to conciliate. The court does it in almost every single matter in the Class 1 of its jurisdiction and Class 3 as well. And importantly, anything that is said or any document provided in the Section 34 conciliation process cannot be tendered in evidence. It's not admissible as evidence in any proceeding, which leads many people to think that, hey, this might be a responsibility-free zone, anything goes, but it's not the ethical black hole that you might think. So, firstly, in terms of obligations, the first one, and the one that those of you who conciliate in the LEC quite a bit will be familiar with, is that in Section 34, subsection 1A, which basically imposes an obligation of good faith upon the parties. And which begs the question, what is participating in good faith? Now, there's one fundamental obligation on every party. And this comes from this decision, Golden Max Proprietary and Limited and Hurstville City Council. To come to a conciliation conference with instructions and authority to enter into an agreement, or at least have the ability to get somebody on the phone in order to give instructions to enter into an agreement. And this arose, it came up in circumstances where Hurstville City Council adopted the position that, hey, they were never going to agree to anything. They didn't want to conciliate. They were never going to ever give instructions to their officers who were appearing at the conciliation conference and their solicitors to enter into a Section 34 agreement. So they ran the position before, I think it was Justice Biscoe, that it would be completely futile to list us for a Section 34 for a conciliation conference because there's never going to be an agreement. Of course, you can gather that the court didn't quite like that approach because the whole point of conciliation conferences, and obviously the obligation is good faith, is to get the parties in a room and at the very least try and narrow the issues, which is consistent with the obligation of the parties under Section 56 of the Civil Procedure Act. And I'll come to that. We'll come to that again in a moment. So the nub of it was that despite the council saying, hey, we're never going to give instructions and there's no utility in listing it for a Section 34, the court listed it for that matter for a conciliation conference, and it said, hey, you need to go as part of an incident of your obligation to negotiate in good faith and have the authority or the ability to get authority to enter into an agreement. But beyond that, because these cases rarely come up, because what's said in a conciliation conference it's not admissible before a court, there's not a whole lot of authority or judicial guidance in terms of what good faith means. So we need to look beyond the Land and Environment Court to guidance about what those words mean elsewhere. I think I'll hand over to Michael, who's going to talk about that now.
Yeah, can I just take a step back to look at the section that Matt mentioned, 134, 1 capital A, and as you can tell from the subsection, it was not originally part of Section 34. It was inserted later. I haven't searched when it was inserted, but it was inserted obviously to correct some evil, and the evil that it sought to correct is obvious, that people were turning up to these conferences, as Hurstville Council did in that particular case, and just sitting there or sending someone who had no authority, or wasting time. And so this provision was inserted to make it clear that there was a positive obligation to act in good faith, or participate in good faith. And so, as Matt said, there's not much guidance on that in the Land and Environment Court, but we've extracted some principles from the case that's on the screen now, Strickland and the Minister. It was a case involving a native title claim, but we think that doesn't really matter. That's just the context of what the claim was about. These principles that we've extracted are about what is an indicator of an absence of good faith in the requirement there to negotiate with native title parties and reach an agreement, the acronym of which escapes me, in Illawarra or some similar type of thing. I can't remember what it was anyway. Not native title lawyers, so we'll steer away from that. But the principles are equally or close to equally applicable in Section 34. And as Matt said at the outset, we are concentrating on Section 34 of the Land Environment Court Act, but the principles apply, or many of the principles will apply in mediations that are directed under the Civil Procedure Act in any court or tribunal. So they're of general application, except where we specifically refer to Section 34 itself.
And in terms of these, whether it also applies the obligation when you're acquiring land to make genuine attempts to negotiate. There's a decision of Justice Beach Jones in the Supreme Court, which in essence refers to Strickland and says that genuine attempts, part of that is making an attempt in good faith. So a lot of these are also relevant to the exercise of the compulsory acquisition power and the issue of a proposed acquisition notice as well.
So, of particular, I mean, some of these aren't, because these principles are extracted in the context of an outside court negotiation, not an inner room conciliation. So some of them aren't particularly relevant, such as one, unreasonable delay in initiating communication. It's not really relevant when you're in a room with someone unless you sit there and say, I'll speak to you in a little while, and just sit there. So it's really two: failure to make proposals in the first place. So you sit in a room and just don't come up with anything, don't exercise your mind. Number 7, failure to take reasonable steps to facilitate and engage. So, for example, that could entail not sending the right people to the meeting, sending some junior clerk who doesn't know what's going on, or someone without any authority, or just having the critical people missing. It goes on. These on this slide are perhaps more relevant things in the context of an actual conciliation or mediation. Failing to respond to reasonable requests. So people might say, well, look, I understand what you've said in your pleadings, but what do you mean by something? And failing to respond to that sort of request for a particular might indicate absence of good faith. Stalling negotiations by unexplained delays. 11, sending negotiators without authority to do more than argue. 12, refusing to agree on trivial matters. I mean, often these Section 34 discussions, conciliations, don't settle the whole matter, but they can still be constructive if you can agree some issues. So you're shortening the hearing, you're reducing risk for the parties, and so you certainly should, if there's a trivial matter that's going to occupy court time, obviously, if you can, you should agree to that, and the absence of agreement to those sorts of things is an indicator of the lack of good faith. 13, shifting position just as an agreement seems in sight. So I've seen that where you're negotiating what you think is the big issue, and you get to a point where it's just about sorted, and then the other side says, oh, but we're really upset about X, and X has hardly mentioned a footnote before now, and suddenly X is a big deal. 14 speaks for itself. Failure to make counter proposals, refusal to sign a written agreement in respect of the negotiation process. We deal with that more specifically a little bit later in the context of Section 34, because Section 34 talks about it describes what the process is, and it also prescribes what happens if an agreement is reached. And so we'll deal with that a little bit more specifically later under what's touched on there as para 17. So those are the indicators of a lack of good faith. Back to Matt.
Turning to another statutory source of your ethical obligations, often referred to, but often overlooked as well, is the Section 56 and the other subsections in there of the Civil Procedure Act. It's not simply an obligation on the court to give effect to the just, quick and cheap resolution of the proceedings being the overriding purpose, but subsections 3 and 4 impose an obligation upon the parties and also the practitioners representing the parties to assist the court to further that overriding purpose. And that is an additional layer of obligation that the Court of Appeal has said on multiple occasions, and that it requires a concentrated deliberation by the parties and even a collaborative effort. So even in this post Civil Procedure Act world that's referred to by the High Court in Aon, there's been a sharp move away from litigating as if it's a war or a game, and there's an expectation on the court that the parties should work together to at least identify the issues in dispute. And what we have here in terms of Section 34, definitely to narrow the issues in dispute to what really is the core dispute between the parties. Now, to give you an example of where this might come in, is where you negotiated a Section 34, essentially come to an agreement, and this happens sometimes. The council refuses to sign the Section 34 agreement, but instead wants to opt for a consent orders hearing. Now, on one view, my view, circumstances where the parties have an obligation to facilitate the just, quick and cheap resolution of proceedings, if the council or the consent authority is content for consent to be granted and thinks that development consent should be granted, then really what it ought to be doing in order to facilitate the overriding purpose is signing a Section 34 agreement as opposed to putting the court to a consent orders hearing. And that's because of the different tasks that the court has. Under Section 34 of the Act, if the parties enter an agreement, the court is required to essentially make the orders in the agreement unless there's a jurisdictional precondition that isn't satisfied, or the court wouldn't have the power to make that decision because of a matter going to jurisdiction. Whereas on a consent orders situation, the court sits as in the shoes of the consent authority, and then in effect considers and determines the matter on its merits, despite the fact that the parties agree. And just before Christmas, in a case called Billiard, I think it's Billiard Investments, I think it was the City of Sydney Council refused to sign a Section 34 agreement, but went to a consent orders hearing. And Commissioner Walsh, despite the fact that both parties agreed that consent should be granted, said, no, I'm not satisfied. I think he quoted the Rolling Stones from memory and said, you can't always get what you want, and refused consent. Now, so there's a risk for parties there too, but ultimately, in the context of Section 56, if you are to facilitate the overriding purpose and enable the disposition of the proceedings as quickly and efficiently, as cost effectively as possible, then the way to do that is by signing a Section 34 agreement, not by putting the court to the cost of consent orders hearing, which in some cases can take days if evidence needs to be called. Moving on from Civil Procedure Act, and more in terms of the conduct rules, I've exerted here the solicitor's conduct rules, but the barrister's conduct rules are relevantly the same if you replace the word solicitor with barrister. But this deals with communications with opponents, which in circumstances where conciliating a Section 34 conference, you're dealing with your opponent, this clearly applies. And Rule 22.1 of the Solicitor's Rules provides that a solicitor must not knowingly make a false or misleading statement to an opponent opponent in relation to a case, including its compromise. So that picks up cases of mediation or conciliations. 22.2, a solicitor must take all necessary steps to correct any false or misleading statement made by the solicitor to an opponent as soon as possible after the solicitor becomes aware that the statement was false or misleading. Now, to give you an example of this, I was involved last year in a leasing dispute and a mediation of a leasing dispute. And in the course of the mediation, I received instructions from my client about a particular matter. And I conveyed that to the other side along with an offer from my client. And whilst the other side was thinking about the offer and going over it, my client said, "Oh wait, I think I was wrong." And actually, when they thought about it a bit more, the instructions that they gave me were incorrect. So I was put in a position where I told a party something that I then found out was incorrect. It was a bit of a, well, despite people not wanting me to correct it, I had an obligation to. In that circumstance, I had to walk out of our room across to them and say, "You know how I said this? Well, that's wrong. We actually mean this. This is the situation." So ultimately, if you ever get in a situation where you say something at a Section 34 conference that you're told that you believe and honestly believe and you're told is correct, but you later found out is incorrect, what you need to do is you need to correct that, because it could involve another party making an offer or agreeing to something that on an incorrect basis, and we'll take you to a case where we deal with scenarios where that actually occurred.
Thanks. It actually goes, this next rule, and the barrister's rule is the same. So it goes a lot further than just not making false or misleading statements or being required to correct any misleading statement you make, because if you become aware that the other party is labouring under a misapprehension, however they came to that misapprehension, if you become aware that they think something that isn't true is true, or vice versa, this rule doesn't expressly say you have to correct it, but it precludes you taking unfair advantage of the obvious error. And so it's a little bit oblique what you are supposed to do there, but I think the appropriate thing to do is probably correct their misapprehension. And we'll talk about a particular case where this happened, and the person who did not correct the error was in strife as a result. So in the context, I suppose, of some of the things that I do a lot of compulsory acquisition Class 3 work where you have a Section 34 conference where you try and reach an agreement. If, for example, the owner of the land was aware that the land was heavily contaminated and became aware that the acquiring authority didn't know that and was making offers on the basis that it had no contamination, no issues at all, that would probably be taking unfair advantage of an obvious error. Whether that's an obvious error, I don't know. It's probably not obvious because it's not discernible, obviously, but I think obvious means apparent to the person who is aware that it's an error, rather than there's oil bubbling out of the ground, because then everyone would see that. So it's quite a broad obligation, and the intent of it obviously is so that there's a level playing field and the cards are, to the extent that they can be, face up on the table, to adopt what the House of Lords said on a different case, rather than all cards held close to the chest and sort of playing battleship with a fence between you, as in the old style. So that's that obligation. This is a slightly different slant. So this is about really overblown types of claims, 34.4.1. And again, in the compulsory acquisition space, you get landowners making, and in this regard it's a little bit subjective, depends which side of the fence you're on, making what looks to the resuming authority like a grossly exaggerated claim, and the converse is probably also true. The landowner walks in and thinks that the acquiring authority is making a grossly underestimated offer. But the key is legitimate. I mean, if you've got experts saying that land is worth a particular amount, then it's legitimate to go along with your expert advice, and that's reflected in the costs rules in the court, where a dispossessed owner generally gets their costs no matter what, even if they end up getting less than the valuer general, unless they act unreasonably. So acting unreasonably does not include having an expert who, it turns out, the court has no time for and rejects all their evidence. 34.1.2 is pretty obvious. In fact, threatening the institution of criminal complaints unless you do something is, when I last looked it up, called extortion, and is a crime in its own right. So that's possibly unnecessary, but it's necessary, I suppose, as a reminder. You often have people screaming and banging the table and saying, "You're not doing this, and I'm going to report you to the Law Society or the Bar Association," and all this kind of thing. Now, a mere threat to report someone to the Law Society or Bar Association is one thing, but if you say, "Unless you give my client lots of money, I'll report you to the Bar Association," that comes under this rule and under the crime of extortion. And, 34.1.3 is pretty self-explanatory. Some people's negotiating style seems deliberately designed to do those things, but anyway, that's perhaps a question of style, and where it goes beyond style is really when you edge upon real threats against people in an attempt to effectively extort money. So we then come across a few actual ethical dilemmas, or that have happened to us. That's mine. So when is there agreement? As I said before, Section 34 prescribes what a Section 34 conference is, and then probably should put this up on the slide, but I'll read it slowly. Subsection 3 says this, and I'll leave out certain words. It says, if at a conciliation conference agreement is reached between the parties as to the terms of the decision in the proceedings that would be acceptable, being a decision the court could have made, the Commissioner A must dispose of the proceedings in accordance with the decision, and B must set out in writing the terms of the decision. So agreement can be reached at a conciliation conference, and as we all know, the discussions in a conciliation conference are without prejudice, can't be relied upon, as usual with mediations, etc. But once an agreement is reached, then that's a contract which is enforceable in accordance with its terms. People generally expect contracts to be in writing, but that's only a requirement of statute. Certain contracts must be in writing, but generally contracts are not required to be in writing. They can be in writing, they can be verbal, they can be conduct, they can be all sorts of things. So recently, and the process in conciliation conferences generally is a commissioner presides, the parties discuss, agreement is reached, and then everyone's happy, and the commissioner then says, okay, well, draft it up, get me the agreement, sign it by the parties, and I'll do the paperwork effectively. But that is really administration, because the agreement, in my view, is concluded once the parties come to ad idem on the points. It recently actually happened to me in a conciliation where agreement was reached, a direction was made for the paperwork. In the preparation of the paperwork, the other side suddenly decided that wasn't what they meant to agree. And so they came back and said, well, there's no agreement because there's nothing in writing. And so that's an ongoing matter, which I won't say any more about. But the provisions are read in mandatory terms. As I said before, the Commissioner must dispose of the proceedings if an agreement is reached. So an interesting question arises as to how do you enforce such an agreement. There's provision in Section 73, I think it is, of the Civil Procedure Act, which gives every court power to enforce compromise of proceedings in that court. So even the district court, which ordinarily doesn't have enforcement powers, can make orders of that nature.
That's the only time I've had to use it in a district court.
Yeah, good luck otherwise finding some equitable jurisdiction in that case. But subsection Section 3411, sub 11, says evidence of anything said in a conciliation conference is not admissible in any proceedings. So we're puzzling this afternoon about how you prove your agreement when you can't get any evidence of anything said in a court. Ordinarily, privilege without prejudice discussions and so forth are just ordinary privileges, like without prejudice communication and so forth. And of course, the court always retains power to overcome those kinds of privilege if the interests of justice demand it. But here there's an actual statutory provision that says what I just read out. And so, as we all know, courts do not like to be deprived of jurisdiction ever. And so a court would come up with a way around that apparent prohibition on proving anything that was an agreement or an alleged agreement in a Section 34 conference, we think.
This kind of situation happens more often than it should. The parties get into an agreement in principle and somebody goes away, thinks about it and says, no, get lost, I'm not going to sign.
You can see it happening in a Class 1 more than a Class 3. A Class 1, there's discussion about window shapes and sizes, and you can see that reasonable minds might differ and the devil might be in the detail. But in a Class 3 proceedings, where there is an agreement that the compensation under the Just Terms Compensation Act is X dollars, it's hard to see how reasonable minds could differ about what that means. Australian dollars or Canadian dollars, you just can't even. It's silly to start talking about what that could, any other meaning that could have. So perhaps the moral of the story is jot something down on paper at the time and get someone to initial it or sign it or something, and then do the formal bits later. But yes, the question 3 on the board, does 2 even matter given a party's ethical obligations? Well, if a party wants to renege on an agreement, I suspect they're not overly concerned about their ethics.
My thought in relation with that is if you go back to Strickland and is that Roman numeral 13 there? Shifting position just as agreement seems inside. Reneging on a 34 agreement is almost a prime example of an agreement in principle is a prime example of that, and that would, according to the federal court, be an example of failure to negotiate in good faith.
And 17 on the next slide is another more express breach. But if the person says, "Oh, I didn't reach agreement," then theoretically, I suppose they overcome all of these problems, at least in their own minds.
Well, so I suppose the other thing is that when the court is determining whether agreement's entered into, it's an objective exercise. So what someone subjectively thinks is going to be given short shrift, I'd hope.
Well, the contract lawyers who are listening would be aware that what's in a person's mind is not very relevant in the construction of what a contract means. You look at what the contract says, and if it says compensation is X dollars, hard to see what a person had in their mind could possibly change that construction. Anyway, to be advised.
The next slide, once I find it, is something that happened to me. And it's a situation that I've heard has come up a couple of times. So under the Environmental Planning and Assessment Act, when someone amends a development application in the course of the court proceedings, there's an obligation on the court to award the consent authority their costs thrown away because of the amendment. But that only applies to a development application, an application of development consent. doesn't apply to a modification application, and it also doesn't apply to a residential development appeal. So, your family trying to renovate their house kind of situation. So, in those circumstances, those people can amend as much as they like as long as it doesn't become unreasonable. So, what happened to me? I had a modification application in circumstances where those provisions don't apply. We were at a conciliation conference, and it was intimated to me that every issue was resolved, but the consent authority would like to have some of their costs paid. And the suggestion was that there would not be a signature on a Section 34 agreement unless there was an agreement in relation to costs. My response to that was to ask three questions. The first one was, I said to them, well, my client is going to ask me three questions. First one is, are they required to pay the costs? The answer to that is going to be no. Two, would the court ever order us to pay your costs? The answer to that is also going to be no. The third question is, well, then why should I pay their costs? Ultimately, I mean, my view is, and you can see from the second question that we've put up here, is it an invitation for a bribe? That you will get a consent if you agree to pay council money that the council otherwise would not be entitled to and would not have a reasonable argument in order to get it in terms of court order. And remember, ultimately, in a conciliation conference, as I said at the start, it's not a responsibility-free zone. You can't make submissions that have no basis in fact or law, because that is ultimately, it could be misleading, but it's ultimately inconsistent with your duty of candour to the court and also your duty of candour in remediation process, which courts have referred to on multiple occasions. So here in this kind of circumstance, I am absolutely adamant, and somebody can tell me otherwise, that it is fundamentally unethical for there to be an insistence upon the payment of money as the price of getting a development consent. And unless someone can point me to some authority suggesting otherwise, or some authority suggesting that there would be a basis for costs to be paid, for a court to order costs to be paid, it's a submission that, or a request that shouldn't be made. Obviously tell I was irked in that conciliation conference when it came up.
Overblown claims. I've mentioned this already in the context of Class 3, where people come along with claims for huge sums of money. It goes back to the obligation, general obligations to the court, that we as legal practitioners should not make submissions to a court that would either mislead the court or that should not be made. We should not run points that have no merit. And similarly, you wouldn't stand up in court and say, Your Honour, this is a claim for $1 billion, stroking the cat, in respect of whatever it is, because you just wouldn't do that. You'd look stupid, and you shouldn't put to a court anything that you can't then substantiate. And really, the fact that you're in a without prejudice meeting, we don't think changes the obligations. You shouldn't make claims in a Section 34 conference, or indeed in any mediation, that you're not prepared to substantiate with real evidence. Or I mean, there's room for people to have widely diverging views, but they have to be views based on something, and not just wander in and say, as happened to me recently, oh, you should pay us $1 million because our claim was originally $5 million, and look how far we've come down. I mean, it's just meaningless. What if they'd started at 100 million? Would 50 million be reasonable? It's just not based in anything. And so that's really all I want to say about it.
But anyway, as practitioners, that also, if you're making overblown claims like that, it's a very small profession. And we're all dealing with the same people all the time. If you're making claims, and how are people going to take you seriously in the future? How are people going to take your client seriously if it's a client who's often in the jurisdiction? So So there's also a strategic benefit to having some candour as well.
So we all know the Latin phrase caveat emptor, let the buyer beware. I don't know if it applies in any area of the law anymore, but it certainly doesn't apply in a Section 34 or mediation type of context. The example that I floated earlier was the landowner who knows that his land's contaminated and remains stum about it on the basis that, caveat emptor, they have to do their own due diligence and I'm not obliged to tell them anything about that. And anyone who takes that view is riding for a fall, as Matt will explain what happened in Legal Service Commissioner and Mullins to illustrate the dangers with that kind of an approach.
Well, it's a personal injury case, so it's very far separated from Land Environment Court. But what it involved was a claim arising from a car accident where the plaintiff was left as a quadriplegic. And the parties evidence had been served in the proceedings that suggested that he had quite a significant life expectancy. The matter was listed for mediation, and shortly before the mediation, a week or so, the barrister who was acting for the plaintiff found out that his client had been diagnosed with cancer, and that significantly reduced his life expectancy. Obviously, when you're dealing with damages for personal injury, the life expectancy is critical because he's basically being compensated for the rest of his working life, particularly in circumstances where he's been rendered a quadriplegic. So the barrister denied about whether to disclose that information to the other side. He spoke to a silk, and it turns out asked the silk the wrong question. And so what happened at the mediation? Ultimately, they did not disclose to the defendant, who was the insurer, the life expectancy, the updated life expectancy as a consequence of the cancer diagnosis. So the insurer was negotiating on the basis that this person, the plaintiff, still had a long time to live. He did not have cancer, and his life expectancy wasn't affected by that. So that was the cancer and the impact on his life expectancy was completely unknown to the defendant. They negotiated on that basis and entered into a mediated agreement whereby a substantial sum of money was paid to the plaintiff. The insurer ultimately found out that he'd been diagnosed with cancer, and that significantly cut his life expectancy in half, and complained that ultimately we negotiated essentially on the wrong assumption. And the suggestion was that the barrister had an obligation to inform the other side of the updated life expectancy. And this was a case in Queensland, and the Queensland, their equivalent of the Queensland Legal Practice Tribunal, agreed, found that the barrister was guilty of professional misconduct, gave him a reprimand and to pay a penalty of $20,000. But it could be much worse if he did it deliberately, because in this circumstance, he'd recognised that there was an issue. He'd tried to consult. He had consulted a silk about it, and he had good prospects of not doing it again. But it was professional misconduct, and certainly if you make it your practice to be aware of certain things that affect a settlement and not disclose them to the other side, you may not be as lucky as Mr. Mullins was in these circumstances, and could go high as being struck off. So the moral of the story is again going back to the rules. If you think that your opponent is operating upon a misapprehension, particularly a misapprehension that you may have induced because of the evidence that has been filed in the proceedings, which is what happened here, in the context of the expert report not having taken into account the cancer diagnosis, because the cancer diagnosis came later. You need to correct it, and you need to make it clear so that everyone is operating in knowledge, or basically on the same baseline. Oh, this is me also. So this is the ambush, which happens perhaps not by design in Section 34 conferences. It can happen by design at hearings. I'm sure everyone's been met with a situation where you haven't received amended plans, and then on the day, bang, here they are, particularly when you're acting for a council and you're told, hey, deal with these, let's talk about these. That it often happens because parties are busily working, they fall behind, and they can't get the material in order in time. But if it is used tactically, it's incredibly problematic. I'll deal with the ethical issue in a moment, but firstly, in terms of the interests of your client, if you are acting for an applicant, ideally you want to get the council to agree to a consent in the conciliation conference. And the way to do that is to give material to the council in advance, so the council has time to consider it. If you lump material on the council at the conciliation conference, they're just going to put their hands up and say, we don't have time to consider this. And the inevitable consequence is the conciliation conference is terminated, goes to a hearing, and the council's under no obligation to negotiate with you again, other than potentially their obligations to 56. But so the case that I've excerpted here was a decision by Justice White, but he was dealing with a trial, but it holds true for Section 34s as well. But in that case, it was essentially an application to wind up a company, and the plaintiff's solicitor had overlooked a requirement in the Corporations Act that the application needed to be determined within 6 months. The defendant's solicitors and counsel were aware of that, and at the time had proposed consent orders, which meant that the matter would be pushed out to such a time that it would have to be dismissed. You can see some reactions saying, yeah, it's pretty bad. And Justice White said in his judgment that he essentially sets out the evidence as that the plaintiff's counsel acknowledged that she and the plaintiff's solicitor had overlooked the requirement in the Act, and then goes on to say, I was surprised to be informed that defendant's legal advisors had not so overlooked the requirement, which is setting up for what is coming. And the submission that was made by the defendant was that he was under no obligation to alert the plaintiff to the pitfalls of that provision. And His Honour, in very blunt terms, said, I disagree. The ambush approach to litigation is discredited. It should be rejected by any solicitor or barrister. It is inconsistent with the duties of parties and their legal representatives under Section 56 of the Civil Procedure Act, which is what I took you to before, to ensure the just, quick and cheap resolution of real issues in the proceedings. And His Honour went on to say that the second defendant and his legal advisors, as much as the plaintiff and his legal advisors, have a duty to cooperate in seeing the issue, the relevant issue, is resolved as quickly and as cheaply as it can be, consistent with it being resolved justly. So again, that picks up on Section 56 and what we took you to before, and that there is essentially a duty of cooperation between the parties in order to focus on the real issues, and that the ambush approach is really the antithesis of that. And usefully in this case, His Honour also exerts some other references as well that really come down hard on the ambush approach. And there's one from Justice Alsop in White and Overland where His Honour said quite definitively litigation is not a game. No one's interests are advanced by litigation proceeding on assumptions which are seen or suspected to be false. And that, again, stating that parties should work together to identify the real issues in dispute in the proceedings, because just be wasting everyone's time if we get up to a hearing after something's been on foot for 12 months and say, hey, we don't know what the case has been. And that's one of the obligations in 34. It's not just about, it's just one of the focuses of a Section 34. It's not just about resolving proceedings, it's about narrowing the issues and disputes, and when you ultimately get to a hearing, the court's time is used most efficiently. What's truly in dispute with the parties is what is determined. And there was another case recently, I won't read it to you, but I like to trot it out often in correspondence where other parties are being pretty obstinate. But it's Darkinjung Local Aboriginal Land Council and Minister administering the Crown Land Management Act. And the reference for that is 2022 NSWCA 275. And Justice Baston is quite critical in that case about the conduct of parties before the Land and Environment Court, actually, and their failure to identify and focus on the real issues in the case, which led to a whole bunch of irrelevant material being tendered, lengthy submissions addressing it, and lengthy discussion in the judgment, which everyone ultimately agreed in the Court of Appeal was completely unnecessary. And His Honour again said that the precepts in Section 56 and Part 6 of the Civil Procedure Act required concentrated deliberation of the parties and should be a collaborative effort. I think we've exhausted some of the ethical dilemmas that we've come across. That's there are no doubt others, and so if any of you had something that you'd come up across or queries that you wanted to ask of us in terms of situations that have come up in Section 34s, we're all ears. Might need to take something on notice if it's particularly complicated.
Gentlemen, you mentioned before, I think you've perhaps answered this, the conflict between Section 73 of the Civil Procedure Act and Section 3411 that says nothing's admissible that happens in Section 34. So you haven't seen that conflict play out?
We've never seen that conflict play out. It might play out in Michael's one coming up, but it's not a straightforward question.
Yeah, it's an interesting thing. Section 73, as you know, provides jurisdiction of any court to determine whether what the terms of any agreement are and to enforce any agreement. How you get evidence of an agreement without adducing evidence of what happened at the Section 34 conference is yes, that's the problem.
It's tricky.
A court is going to say, well, I don't know what a court is going to do. It doesn't require much for a judge to find jurisdiction. They don't like to have their jurisdiction negated. And so it would require not much mental gymnastics to say, well, there's a conflict between Section 73 and Section 34. For me to be able to exercise the jurisdiction, it's clearly given me the Civil Procedure Act, which is the act governing civil procedure. I need to be able to determine what the agreement is alleged to be, and thus, to the extent there's a conflict, I read Section 73 as overriding Section 34 so that I can find out, the judge can find out what is alleged to have happened at the Section 34, and people can call evidence about that, and notwithstanding Section 34 says you can't do it, you have to do it because of Section 73 or something. So I can't see a judge saying, this matter comes before me to enforce an agreement alleged to have been reached in the Section 34 agreement. Unfortunately, I can't know anything that happened, so application dismissed. I mean, that's just... it might happen, but...
on one view, you could have a situation where you enter into an agreement, and the obligation, as Michael set out before, is that the Commissioner has a duty to make the orders if it has jurisdiction. And that could give rise to an application for mandamus, by which the Court of Appeal has supervisory jurisdiction, and that can't be outed, as the High Court made clear in Kirk.
But again, how do you get the evidence in? Whether it's mandamus or whether it's enforcement of 73.
Well, wouldn't the answer be that that provision can't override the supervisory jurisdiction of the Court of Appeal?
Well, I don't know. It's
a
statutory
you don't really want to go to the Court of
it's
Appeal.
It's a statutory court, not the Supreme Court. If it was the Supreme Court, I'd agree that there's inherent jurisdiction of the Supreme Court. maybe they get in under inherent jurisdiction. I don't know.
It is a really tricky question.
It's tricky.
It's never come up before because everyone's
all these 34 conferences going on, right?
Yeah. Well, look, you've heard there's been situations where people have made cost applications and they've tried to rely upon things that have said in the Section 34 and they can never get it in, including in relation to allegations of good faith.
But that's not enforcement, so
it's not enforcement.
No.
It's a different kettle of fish, and there's a clear interest in avoiding that because people want to be able to negotiate basically as openly as possible and don't want to have anything said held against them and have to pay money for it. So, but Michael's situation's a bit different.
we'll see what happens.
I act for councils a bit, and they've always been well behaved. I think I know the answer to this, but what's driving councils to want to force what would be a Section 34 agreement to a consent orders hearing? Is it just political? They don't want to be seen to be...
Often it's the optics.
Yeah.
That we don't want to be seen by the objectors to be approving this.
Surely the court takes a dim view of that? Or...
Well, you get a flavour of the advice that I would give to my clients because of what I've said already. So I haven't been in a situation before where I've had to go to a consent orders hearing when there's an agreement.
Unhappily, when...
Yeah, everyone who I've acted for, when they're happy, is entered into the Section 34 agreement. Pardon?
Did you get told off?
No. But I've heard of situations where the court's been very frustrated with people because they've been forced to go to consent orders hearing. And that's understandable because it makes their job harder and they've got more work to do. But
It's not quick, just a quick and cheap.
it's definitely not just quick or cheap. So, but there is the option of it. And if any council who insists upon it is just going to say, well, if it would be improper for us to do it, then there wouldn't be such a thing as a consent orders hearing. That's the counter argument.
All right.
Cool. So,
No other questions? I'll
check out online
No
live
one's-
chat.
No one's got their hand up or whatever.
Nothing on YouTube, so
If I'm Mr. Mullins, can I just return the brief and wash my hands of that problem? Surely. That'd be the quick, clean way out.
a clean way. Well, only if Mr. Mullins says, Mr. Mullins is the barrister.
Oh,
No,
yeah.
only if the plaintiff says no, don't disclose.
Yeah.
That would be the clean way out. Whereas, because we're not mere mouthpieces for our client ever, and that comes out to back to making overblown claims. If your client says, "Oh, say this, say that," if you know there's no foundation for it in law and fact, you can't say. Anything to add, or is it-
No.
Thank you for those who
Thank you
have
all.
come in. Thank you for those who are viewing from the comfort of their own home.